Breaking news from the Supreme Court that could eliminate firearm permits across the entire country. We have a massive update on the emergency case that's sitting on the justices' desks right now, scheduled for conference next week. This could completely change how Americans exercise their Second Amendment rights. The Trump administration just filed a brief supporting this challenge. And multiple circuit courts are now in direct conflict over whether states can require permits before you exercise your constitutional rights. Hit that subscribe button because you need to hear what's happening in this critical case. Music, the case that could end all permits and the case that could end all permits. The Supreme Court is currently reviewing an emergency petition that directly challenges the entire concept of requiring government permission before exercising Second Amendment rights. The case involves multiple states that created elaborate permitting systems after the Bruin decision in 2022. Thinking they could work around the Supreme Court's ruling, these states implemented requirements that force citizens to pay fees ranging from $50 to $340. Complete training courses that cost another $200 to $500. Provide character references from multiple people. Sit through in-person interviews with law enforcement, and then wait anywhere from 30 to 180 days for approval. In Maryland alone, over 47,000 permit applications were delayed beyond the statutory time frame last year, with some applicants waiting over 8 months. New Jersey rejected 23% of all permit applications in 2024, often without clear explanation. What makes this case different from previous challenges is that it's not just about concealed carry anymore. This case attacks the fundamental premise that you need to ask the government for permission before purchasing or carrying a firearm. The Trump Doge game changer out of the Trump DOJ game changer. The Trump administration's Department of Justice just filed an amicus brief that legal experts are calling one of the most aggressive Second Amendment filings from the federal government in modern history. Attorney General Pam Bondi personally signed off on a brief that doesn't just support the plaintiffs. It systematically dismantles every argument that states have used to justify permit requirements. The brief cites over 60 historical sources and concludes that not a single founding-era law required law-abiding citizens to obtain a permit before purchasing or carrying common firearms. This is significant because during the Obama and Biden administrations, the DOJ consistently sided with states in these cases or remained neutral. The Trump DOJ brief specifically calls out 9 states by name for operating what they describe as unconstitutional licensing schemes that function as de facto bans. They point to data showing that in Los Angeles County, only 197 concealed carry permits were issued to the county's 10 million residents before brewing. In New York City, the number was even worse. Just 2,196 permits for 8.3 million people. Through the circuit split nobody's talking about right now. Whether you need a permit to exercise your Second Amendment rights depends entirely on which federal circuit you live in, and the contradictions are stunning. The Third Circuit just ruled that New Jersey's permit to purchase law violates the Second Amendment, finding no historical tradition of requiring licenses for firearm purchases. That decision affects roughly 15 million people across 3 states. Meanwhile, the Fourth Circuit upheld Maryland's similar law affecting 19 million people in 5 states. The Ninth Circuit sided with Hawaii's permit scheme impacting 40 million residents. This means 2 people living 50 miles apart on opposite sides of a circuit boundary have completely different constitutional rights. A resident of Philadelphia can purchase a handgun without a permit thanks to the Third Circuit ruling. But someone in Baltimore, just 95 miles away, needs a permit that takes 30 days minimum to obtain. Legal scholars have identified at least 14 different standards that various circuit courts are using to evaluate permit requirements post-Bruin. Some circuits apply strict scrutiny. Others use intermediate scrutiny, and some have invented entirely new frameworks of the hidden tax on constitutional rights. Permit systems have quietly become one of the most profitable government programs in anti-gun states, generating over $185 million annually in application fees alone. New York's concealed carry permit costs $340 for the initial application plus fingerprinting fees of $11.50 and required training courses that average $250. That's $691.50 before you even know if you'll be approved. And the state keeps every penny even if they deny you. Illinois has issued over 440,000 concealed carry licenses since 2014, with each one costing $150 for residents. That's $66 million in revenue from a constitutional right. But the real costs go far beyond the application fees. A study from the Crime Prevention Research Center found that the average total cost to obtain a concealed carry permit in may-issue states before BRE $1,135 when factoring in training fees, time off work, and travel. In New Jersey, applicants must provide references who are then contacted by police, photographed, and sometimes visited at their homes. The approval rate scandal. Analysis of permit approval data from 6 states reveals a disturbing pattern that suggests these systems aren't about safety, they're about control. Before the Bruin decision forced New York to change its standard, the approval rate for concealed carry permits varied wildly by county. In Manhattan, the approval rate was 0.45%. In upstate counties, it was as high as 89%. The difference wasn't crime rates or population density. It was the political makeup of the licensing authorities. A 2021 study examined over 2.3 million permit applications across 8 states and found that denial rates had almost no correlation with crime statistics, but showed strong correlation with the political party of the issuing authority. Counties with Democratic sheriffs or police chiefs denied applications at rates 340% higher than Republican-controlled counties, even when controlling for population and crime rates. No explanation, no appeal, no explanation, no appeal, no rights. In most permit-required states, applicants who are denied have virtually no meaningful way to challenge the decision. New Jersey law allows authorities to deny a permit based on a determination that the applicant lacks good character without defining what that means or requiring specific evidence. A 2023 analysis found that 67% of New Jersey permit denials provided no specific reason beyond boilerplate language about failing to meet statutory requirements. When applicants try to appeal, they face a system designed to discourage challenges. In Maryland, appealing a permit denial requires hiring an attorney and filing in circuit court, with average legal costs exceeding $8,000. Only 3% of denied applicants pursue appeals, and of those, only 11% succeed. The historical evidence is damning. The Trump DOJ brief includes a devastating historical analysis that examined over 180 years of American gun laws and found exactly 0 examples of permit to purchase or permit to carry requirements for ordinary citizens before the 20th century. The first permit purchase law wasn't enacted until 1911 in New York, and it was explicitly designed to keep firearms away from Italian and Eastern European immigrants. The legislative history includes openly racist statements about keeping guns away from undesirable foreigners. The Sullivan Act, as it was called, was sponsored by a Tammany Hall politician, later imprisoned for corruption. Concealed carry permit requirements emerged primarily in the 1920s and 1930s, often with explicitly discriminatory intent. A 1941 Florida Supreme Court decision stated plainly that the state's permit law was intended to create a system where officials could deny permits to black residents while approving them for whites. Why the Supreme Court might actually take this case. Supreme Court conferences are typically where petitions go to die. The court receives over 7,000 petitions per year and grants fewer than 80. But this case has several factors that dramatically increase its chances. First, there's a clear and undeniable circuit split with at least 4 circuits ruling differently on nearly identical laws. The Supreme Court exists primarily to resolve such splits. Second, the case involves a fundamental constitutional right affecting over 100 million gun owners across the country. Third, and most importantly, the federal government is actively pushing the court to take the case and resolve it. Now, when the Solicitor General files a brief urging the court to grant certiorari, the justices listen. Historical data shows that cases supported by the Solicitor General are granted review at rates exceeding 70%. This case doesn't require the court to break new ground or establish novel theories. It simply requires them to enforce what they already said in Bruin. Conclusion: if this case gets accepted by the Supreme Court, we could see the biggest Second Amendment victory in American history. Make sure you hit that subscribe button and turn on notifications because I'll be breaking down every development as soon as it happens. Smash that like button if you want to see permit requirements struck down nationwide. Drop a comment below telling me which state's permit system needs to be eliminated first. Share this video with every gun owner you know because they need to understand what's at stake here. This nation was built by armed scholars, and this nation will be maintained by armed scholars.